Hi, everyone. Thank you for joining me for this new and special episode of Who Cares? And I say it's a special one because I have a panel again, a panel of guests. They are lawyers that I'm lucky to call friends and colleagues. I have with me Anita Szigeti, Carter Martell, Sarah Rankin, and Cassandra DeMelo. And the reason why we're here today is because we all worked on a case, a Supreme Court case, and the decision was recently released. It was released on July 28th, and it's R versus Kahsai, 2023 SCC 20. And it is a decision in which the court talks about and defines the proper scope of the role that amicus curiae, or friend of the court, can play at a criminal trial. Just as a brief background about the case, I will just give you some factual background so you can have some understanding for those who haven't read the case. This is an Alberta case where Emmanuel Kahsai was charged with 2 counts of first-degree murder in the killing of his mother and Miss Tran, who was under the primary care of Mr. Kahsai's mother because of her serious developmental challenges. Mr. Kahsai was tried by a jury in the Court of Queen's Bench in Alberta. Mr. Kahsai was unrepresented and displayed behavior that put his fitness to stand trial into question. 3 psychiatric assessments found that he was fit to stand trial, but that he was feigning the symptoms of mental illness for ulterior motives or for strategic purposes. The case management judge appointed a 486.3 counsel to cross-examine the Crown witnesses in the case, and the trial judge appointed Amicus to help with jury selection. But Mr. Kahsai's behavior in court was disruptive, and as a result, he was often excluded from participating in the proceeding because of his behavior. When he did participate, he advanced no meaningful defense. Partway through the trial judge determined that the appointment of the second amicus was necessary for this case to be justly adjudicated. And throughout the proceeding, however, trial amicus made remarks that conceded his lack of familiarity with the case. Mr. Kahsai resisted the appointment of amicus and refused to cooperate with him throughout the proceedings. Mr. Kahsai advanced no theory that would give rise to a defense. He was found guilty of both counts of murder and sentenced to life in prison with no possibility of parole for 2 consecutive periods of 25 years. Mr. Kahsai appealed his convictions and argued that failing to appoint amicus with an adversarial role at an early stage in the proceedings tainted the perceived fairness of his trial. The majority of the Court of Appeal found that there was no miscarriage of justice and dismissed the appeal. The majority's view was that the appellant deliberately caused the court process to derail the proceedings and abort his trial. After that strategy had failed, he sought to complain that a miscarriage of justice had occurred, and as such, he should not be rewarded with a new trial. The majority also reasoned that deference is owed to the trial judge's discretion not to appoint amicus with expanded role. In this case, Mr. Kahsai insisted on not being represented by counsel. Appointment of amicus with defense-like functions would have violated the appellant's asserted right to represent himself. So with this background in mind about the factual basis underlying this case, I would like to turn to you first, Anita. And first of all, thank you for being here because you were one of the main lawyers who worked on this case and representing the Empowerment Council, was our client in this case. I would like you, Anita, to explain to us what is the history of the role of amicus.
Thanks, Maya, for the question. And also thank you for hosting this special episode of Who Cares about Amicus. It's really great to be here with this exceptional team of lawyers that we pulled together to represent the Empowerment Council on Kahsai in the Supreme Court, and also to have Sarah here with us, who had represented her client, the CCLA, with such grace and poise in her oral argument, which I really encourage everyone to watch. Let me start by saying that this judgment from the Supreme Court of Canada is incredibly important and will have broad ramifications for accused persons throughout criminal justice. But also beyond that, for persons with serious mental health issues in many other proceedings, including civil commitment proceedings and on NCR fitness issues and before criminal code review boards. Because the decision will have such wide-reaching impact, even though it arose in the particular context of a homicide trial with an unrepresented accused, it was very important for our client, the Empowerment Council, to participate as an intervener. This is because amicus curiae appointments are most often necessary where mental health is an issue. Or to put another way, amicus appointments are needed in disproportionate numbers, where an accused person or other litigant has serious mental health issues and as a result is either seeking to self-represent or cannot maintain a meaningful relationship with counsel, for example. It's often more difficult for people with serious mental health issues to represent themselves effectively due to the complexity of legal proceedings. But it should not be assumed that someone who has a mental health issue is incapable of representing themselves just because they have that mental health issue. These decisions must be made on a case-by-case basis. Now, that being said, the role of amicus curiae in mental health matters is itself extremely complex and should be undertaken only by those who are truly expert in the relevant area of the law and have significant experience working with individuals with serious mental health issues. Now, personally, as many of you will know, I was very invested in this case because of my own history in acting in the amicus capacity over the last 25 years. I think I've been repeatedly appointed as amicus by every level of court or tribunal I've appeared before, and that includes, funnily enough, the Supreme Court of Canada, which appointed me into a very defense-like role in 2002 for an individual to whom I had in fact been counsel before then. So I point this out because it's one of the sort of contested issues within this case. It was also important for the Empowerment Council and for me to be part of this conversation on Kahsai, because Kahsai provided an opportunity to revisit the CLA and AG judgment out of the Supreme Court 10 years ago, which had completely changed the landscape of when and how amicus curiae could be appointed by trial courts. So for those who are interested in the origins of this case and interested in CLA and AG, it is indexed as Ontario versus the Criminal Lawyers Association. And I'll just give you the citation so you have it handy if you feel like reading it. It's 2013 SCC 43. The background to that judgment was the 2009 boycott of legal aid by criminal defense lawyers led by the CLA, because we had not had a raise in decades. So we started a job action and refused to take legal aid certificates on some of the more serious matters. Defense lawyers had also come to reject accepting amicus appointments at legal aid rates on the basis that if the court required our assistance, the court was not an indigent accused, and the Attorney General should pay a fair rate for the services that the court, in fact, required. But the Ontario Attorney General refused to pay anything about legal aid rates, citing that the court had no jurisdiction to order the expenditure of public funds as a way to get around the provincial legal aid scheme. This fee dispute was actually at the heart of the Crown appeal to the Supreme Court of Canada in that case. However, when the court allowed the Crown appeal in a 5-4 judgment, they went on to comment on the proper role of court-appointed amicus by highlighting a number of dangers that appointing amicus into a de facto defense role would risk. And those risks were identified as one, using the amicus appointment as an end run around refusal of state funding for defense counsel. Two, a conflict the lawyer may have between their duty to the accused versus their duty to the court. For example, the lawyer may have to make submissions contrary to the interest of the accused. And three, that the amicus might be acting beyond their role as counsel to the court by doing things that the court itself could not do where an accused is self-representing. So basically, at that relevant time, trial courts were routinely appointing amicus curiae, most often defense counsel who had been discharged right before trial, in lieu of defense counsel, and often ordered the AG to pay amicus at higher than legal aid rates. The Supreme Court of Canada said this could not continue for a host of reasons, and that the appointment of amicus should be made only in exceptional cases, and rates could only be determined by the Attorney General. The court said if no amicus agreed to the legal aid rates, or where negotiations with the Attorney General on rates was unsuccessful, the court could stay the charges and explain that a fair trial was not possible under all of the circumstances. Now, 4 judges of the Supreme Court of Canada disagreed and indicated that courts have the ability to determine the rates of amicus, and if the AG did not want to pay a higher than legal aid rate, they could choose not to pursue the prosecution of the matter. The upshot and perhaps unintended fallout from CLA and AG, however, went well beyond the fee decision, in that many trial courts and hearing tribunals got the message that the amicus curiae they appointed could not act in a defense-like role at all, or in the language of Kahsai, in a partisan role. This had a particularly disproportionately adverse impact where mental health issues were concerned. So where a quote unquote neutral approach to the role of amicus was undertaken, this was of no meaningful assistance in ensuring trial fairness in the context of an accused who is either doing nothing to advance any defense on their own or on their own behalf, or is not participating effectively or meaningfully in their own defense, despite being fit to stand trial. So I'll just conclude by saying, one of the more troubling collateral adverse effects of the CLA and AG judgment was that the Ontario Court of Appeals amicus roster for mental disorder appeals, which had handled about 50 appeals a year starting in 2000, ended abruptly in the wake of this judgment in 2013 for a host of reasons, but among them, the limitations that this decision established on the role of court-appointed amicus. So for all of these reasons, given that historical background about CLA and AG and in the wake of CLA and AG, our client, the Empowerment Council, and I personally were very keen to return and revisit these issues fully and directly in the Supreme Court of Canada without the distraction of the fee dispute that was the triggering issue in CLA and AG. So sorry about that. It was a very long answer, but it's a fulsome historical exploration of the role. Over to you.
Yeah, no, thank you very much, Anita, for this explanation about the history of the role of amicus. I know you say amicus. I pronounce it a bit differently, but I mean, I don't know who's right and who's wrong. But right. Yeah, you're always right. I will now turn to you, Sarah. Thank you for joining us today. Sarah is joining us from Alberta, which is where this case actually took place. The trial in this case took place in Alberta. And Sarah, I wanted you to tell us, please, who was your client in this case? Who were you representing? And what was the contribution that your client made to the case?
Yes, thank you so much for having me. It is a pleasure to talk about this case. The first CLA came out when I was a very junior lawyer, just recently law student. And so following this through and being a part of this particular iteration was a bit of a dream come true, in particular because I was fortunate enough to represent the Canadian Civil Liberties Association, which is a national organization focused on law reform and both interventions into legislative steps as well as legal cases aimed at ensuring that the law best protects the civil liberties of Canadians. And so the contribution, the concern that the CCLA had coming into this case was about some of those issues that I think Anita was talking about. The role of amicus and there's the tension in defining and understanding the role of amicus, and I say amicus so we can have a subsequent case to decide the pronunciation.
I say amicus as well.
But there's a real tension there between the risk that a trial will occur that's unfair with a defendant who, through no choice that they're making with this intended outcome, will have a trial that's unfair where the evidence is not fully canvassed. But the flip side of that is the right to represent yourself and the fundamental autonomy and dignity of defendants. And that at the end of the day, it is the defendant who suffers the consequences, experiences the fallout of the case. And so there is a lot of paternalism potentially built into a system that foists counsel on them when they're unrepresented and drives the arguments that are made potentially against their will. And so the way that it was one of the more interesting, challenging issues that I've ever had the pleasure of working on in my career. And one that called for a lot of nuance, a lot of discussion. I don't know that I've ever gone back and forth on drafts as many times, because where we ended up, I think, and what I'm proud of having contributed is that the more detailed and the more specific discussions of amicus get in any particular case, the better equipped any decision maker is going to be to manage the tension between those two issues. So in the original CLA decision that Anita talked about, the role of amicus is described in very broad strokes as, if they become defense counsel, if they're cloaked in all the responsibilities, that's unacceptable. But there isn't a lot of discussion, and in fairness, it wasn't the central thrust of that case, about what that means, what defense counsel does. And on the other side, the decisions in this case going up place a lot of emphasis on the autonomy of the defendant, that he was not represented at trial, that he participated in aspects of the trial, and that if amicus had had a larger role, that may have tread on his decision-making, his autonomy. And I think that what this decision makes possible is to find that middle ground and thread the needle through getting more precise. If a defendant is advancing some sort of defense on their own, what are the contours of that? What would be inconsistent? What would impair that self-representation? And what is it that their autonomy interest in a particular case consists of? It's not just being self-represented. It is arguably not being wrongfully convicted if they're in a situation where they don't have counsel, not through choice, but because they're, perhaps emotional issues falling short of fitness mean that it's difficult to maintain a relationship with counsel, but they've tried. And so I think that the thing that we wanted to bring to the law in this area was an emphasis on more detail and more specifics when courts are engaging in appointing amicus, because the duties that amicus has, they're going to shift in every case. And the way that I would suggest that they're best arrived at or best defined is going to be some combination of very clearly identifying why the court is compelled to consider amicus in the first place. What does the court perceive as missing? What is the court concerned is happening or not happening? What is the court anticipating? And on the other side, what information does the court have about the perspective of the defendant, the objectives of the defendant? And so appointments that are grounded in that much more specific and much more, incremental, that stuff will evolve over a trial. Amicus can help it evolve, that we will be able to find the right balance in any particular case if we get much more specific about what's at stake and what is driving that potential appointment and the hesitations about any potential appointment.
Thank you very much, Sarah, for this answer and for being here with us. And now I turn to you, Carter, and I would like you to tell us, what did the Supreme Court decide finally in Kahsai about the role of amicus? If you can explain that to us, please.
Sure. So, as Anita mentioned, CLA v. Ontario was interpreted as having put an end to this practice that had developed in Ontario of trial courts routinely appointing amicus in difficult and complex cases to take on a role similar to defense counsel. Now, in cases where self-represented or unrepresented accused either refused to participate or were just manifestly unable to defend themselves effectively. And often mental health challenges were part of the picture in those cases. CLA seemed to say that Amicus shouldn't be taking on any of the roles and responsibilities of defense counsel, and some interpreted it as having restricted Amicus to making neutral submissions meant to educate the court on the state of the law. So this interpretation proved problematic because trial judges in the kinds of cases where previously they would have appointed a partisan amicus found themselves faced with a lopsided proceeding, with nobody to challenge the Crown's case or position on the law. And out of this conundrum came two decisions of the Ontario Superior Court, one called CML and one called Jaser, in which the trial judges found that the CLA could not have meant that amicus could never take an adversarial position or advocate for the interests of the accused. They found that the things that caused the court in CLA to caution against the appointment of a defense like amicus weren't really live concerns in these complex cases where the accused refused to participate or were incapable of participating meaningfully by challenging the Crown's case. They said there's no conflict between amicus and the accused's right to self-represent if they're not meaningfully self-representing. There's no concern about doing an end run around the provincial legal aid scheme if the accused does not want state-funded counsel. And the Ontario Court of Appeal took the same approach in a case called Walker, which involved a dangerous offender proceeding with an accused who was self-represented, but due to a combination of mental health and cognitive challenges, was incapable of participating meaningfully in the proceedings. And in fact, she found them so distressing that she had to be excluded at times and eventually just stopped coming to court. So this lengthy dangerous offender proceeding was conducted in large part without her there. The trial judge appointed amicus and instructed her to essentially act as defense counsel. And the Court of Appeal found that although there were problems with the way that amicus discharged that role, the trial judge didn't offend CLA by making that amicus appointment. Justice Fairburn wrote at the Court of Appeal for Ontario that in cases like this, where there's an imbalance in the capacity of the parties to perform their adversarial functions, the adversarial system that is fundamental to our system of justice risks losing much of its force. But I think there was always a question about whether CML and Jaser and Walker could truly be reconciled with CLA. So the Supreme Court has cleared up that uncertainty in Kahsai and endorsed those decisions, all of which are cited in the Kahsai decision. And in fact, the Supreme Court quotes and expands on Justice Fairburn's comments in Walker about the necessity of an adversarial trial process, both for the accused and for the public at large, who have an interest in an effective and truth-seeking adversarial process. So the Supreme Court said in Kahsai, in those exceptional cases where the trial judge of the Crown's obligations to assist an unrepresented accused are not sufficient to ensure a balanced proceeding and a proper adversarial process, the appointment of amicus may be necessary to avoid either a miscarriage of justice or the appearance of one, and the trial judge has a wide discretion to tailor the roles and responsibilities of amicus to the needs of the case, including by having them take an adversarial position on the evidence or the law to restore balance to the proceeding. Now, the court says that the trial judge's discretion is not without its limits. They have to be careful not to interfere with the accused's right to self-represent. So amicus can't make submissions or seek to elicit evidence that undermines the accused's own theory of the case. And there are restrictions that flow from amicus's duty to the court, because amicus is appointed to help the court, not to assist the accused, although the accused might incidentally benefit from the appointment. So amicus can't enter into a solicitor-client relationship with the accused, because that could create a conflict of interest between the duty to the client and to the court. And they can't give strategic litigation advice, because that would be inconsistent with the court's duty to remain neutral. But amicus might, for example, make submissions on the admissibility of evidence, cross-examine witnesses, or make closing submissions to the jury. So the decision is really important. I think some judges and tribunals have been hesitant following CLA to appoint amicus because of the uncertainty about what roles were left for amicus. But now we have this very clear guidance from the court about the kinds of cases where the appointment might be appropriate and the scope of the trial judge's discretion to tailor the appointment.
Thank you very much, Carter, for this explanation about the Supreme Court's decision in Kahsai. And I now turn to you, Cassandra, to tell us about your experience as a trial lawyer and a lawyer who's in the trenches, who's been dealing with a lot of cases, mental health cases. Tell us, what did you, maybe how are these amicus cases, how were they before the decision from the Supreme Court in Kahsai? And what do you think, or how do you think this decision will impact the practice going forward?
Thanks, Maya. So I think prior to Kahsai, there was very few amicus appointments being made as a result of everything that's already been said, just the uncertainty of what was left for amicus or amicus to really do. And so I myself only saw amicus orders being given to me a handful of times over a number of years. And that was also a really difficult role to take on as counsel. It put counsel on the ground in a very uncomfortable position because you were always wondering if you were taking a step just too far over that line of trying to be partisan to the court and be friend of the court only without giving legal advice to the client or the accused. And what I hope comes from Kahsai is an ability of all justice participants to see amicus as a opportunity to do these types of orders more often, to not shy away from them, and also to really spend time at the outset when the order is first being sought, clarifying what the role of the amicus person will be. Because I think if there's clarity from the outset as to what the amicus counsel is going to do or what the expectation is, then it makes it more straightforward for us as well as counsel. And that's challenging because I find typically when an amicus appointment has been made, you're coming on after the order has already been made. And so sometimes you weren't there as counsel for the process where it was the order was being drafted and discussed and then entered into. However, that doesn't and shouldn't stop counsel from realizing that that order can be revisited. And you should ask the judge for an opportunity to revisit the order and perhaps ask for a subsequent or an amended order if it's unclear to you the extent to which your role should take. Because, of course, we want to make sure that we're honoring Kahsai and expanding the role, but you also don't want to just kind of take free rein and assume that you can play a much more adversarial role and then accidentally overstep anyways, right? So I think the best advice that I can think of in implementing this on the ground level moving forward is clarity from the beginning is going to be very important. And that means the judge, the lawyer, and even Crown should be discussing these things in a really, really meaningful and intentional way to ensure that there's no further room for ambiguity or just simply misunderstanding about what the role is intended to be in that particular case. Because as it's been said by my colleagues here, it's not ever going to be the same thing. It's going to, by definition now, be different or require different things from counsel depending on the specifics of that case. So that's maybe both a power and a drawback of the reality of amicus, but at least now we have the ability to ask for a bit more leeway and to play a bit more of an adversarial role to help ensure justice is seen.
Thank you very much, Cassandra. And Anita, Carter, I don't know if Sarah is still here with us on the video, but I just wanted to ask you just before we end this, if anyone had any final thoughts. Anita, you can go ahead and tell us if you have any final thoughts.
I have some thoughts. I'll just flag a couple of things based on what you've heard from Cassandra, Carter, and Sarah as well. I encourage you to read the Kahsai judgment because it's very illuminating in that Justice Karakatsanis writes that the court adopts what they said in CLA and AG and expands upon that and builds upon it. But ultimately, a careful read will tell you that it's a bit of a 180. So whereas previously, the message was you can't really be particularly defense-like, I think the state of the law now is you really can, subject to just a couple of things that you absolutely cannot do. So the main thing you cannot do as the partisan amicus in any circumstance is start advancing a strategy that goes against the strategy that a self-rep or an unrepresented accused has decided to pursue, right? So you can go against something that is actively being pursued by the accused. But if the accused is doing nothing, I think from this judgment you learn that as amicus you can have a theory of the case that through your cross-examinations and submissions you may be pointing the court towards. So I mean, read it carefully, but there's very little that's off the table ultimately. In some circumstances that would call for it. And I think what the upshot is that there's broad discretion in the trial judge to appoint amicus, and there's also broad discretion in the role that amicus is going to be directed to play. The second comment I would make is pay some attention to a case called Barwani out of the Court of Appeal that we talked about at the CLA Spring Conference. The sort of timing on these cases traveling together in a way was that the Supreme Court had an opportunity to consider Barwani out of the Ontario Court of Appeal released a few months ago, and has in a way already affirmed part of that judgment with respect to the Taylor test for fitness not being changed, because one of the concerns in Barwani was that perhaps we need a higher threshold test for fitness, which would of course guarantee appointment of counsel for those who are found unfit. So you would have more sort of lawyers representing people with serious mental health issues if the fitness test were raised. But Kahsai, so reaffirms the low test for fitness, and that instead of appointing counsel for masses of unfit people, this business of a partisan amicus where there's serious mental disorder, even though someone has been found fit based on that low threshold, but are not effectively representing themselves, that's the solution. So I think you want to read these things together, although also being mindful of the fact that leave has been sought to the Supreme Court of Canada in Barwani, which has an NCR component as well. But these are both important cases, and so I would suggest that you do read them all, read them both carefully. But I think, overall, a very welcome clarification in an area of law that was, fraught with uncertainty and is ethically a minefield for counsel.
Thank you very much, Anita, for that. And if no one else has other points or thoughts, I wanted to thank you all for being here today, despite your very busy schedules. I know we're all very busy right now, and but it was a pleasure to work with you all on this case. It was a lot of fun. It was nice to see you all talk about this right now. And thank you for your time.
Thanks, Maya.
Thank you, Maya.
Thank you.
Nice to see everyone.
Thanks.